Well, a pleasant good morning and welcome to the CCG hour. I am so excited about this morning because we are outdoors. We are at beautiful Monks and Irvans. And oh my goodness, it's been years since I've been here. I was here as a little girl and I did, well, not a little girl, as a young lady when we did core retreat. For those of you who are Catholics out there, you had to do core, you just had to do core. And it was wonderful. And I'm back here and my goodness, it's just so many memories. But today we are going to continue to talk land because I'm back here again with Naeisha, all excited. So I'm actually in Naeisha's backyard. Naeisha, good morning.
Good morning, Wendy. You are in my home.
I know, right? It is so beautiful up here. And trust me, I'm envying Sister Roxanne. I'm like, my goodness, they get to live here. It's
but I so get beautiful. To live very close.
Yes, and you get to live there.
And
you can come up.
Visit the retreat center at St. Martin's quite often.
Yes.
Sometimes daily.
You see, look at what you just showing off.
And I'm just rubbing it in right now.
Yes, too much. And then you went all on the swings. I have a feeling, I'm sure, I'm hoping it's not you that mash up the people's swings.
I did not, I promise I did not break the swings.
But it's so beautiful up here. And of course, a lot of you, I'm very sure, just know of, we don't have a history of the place, but I'm sure that most of you, once you're Catholic, and maybe many other religious groups, enjoy this beautiful place. I was saying to Naeisha that it just reminds you of how much we want to go to heaven. But of course, we're down here on earth. And we're grateful for what God has blessed us with. Anyway.
It's a beautiful garden. Today it's a beautiful day. No, it's very sunny.
It is.
We've had some showers and I think the plants are enjoying that.
Oh, yes.
And it's just marvelous here. And every time I feel a little overburdened with all the problems, including the ones that law can bring about. And that
land that we're talking about can bring about, I'm sure.
Land issues. I come here and it's just a place of repose and rest, and you can feel very refreshed. And if any of the viewers, have heard of this, it's something that you should really try to do. Well, it's really very pleasant experience.
We'll give some free advertisement one time for Sister Roxanne and Monks and Irvans. So, yes, it's two of them, Sister Roxanne and Sister Julie.
Yes, there's a couple of others.
So, yeah, it's a whole team, but it's just that I'm remembering Sister Roxanne because, of course, I got to meet her and she and I had such a wonderful chat.
Marvelous.
So, we just doing our bit. Now, listen, they didn't tell us to say that, right? So, please. Just bear with us. So we are saying, please just come on up, call them, have a chat with them. And if you have a group of persons, and there is a conference room as well. So if you have a group of persons that you just want to, you want a meeting, but more than that, you just want to relax from the hustle, the bustle. As a matter of fact, you can have family reunions here. We don't want rowdiness and ruction up here. No. If you are that crowd, then this is not the place for you. But if you do want to just relax, you want to get away from it all, you want to spend time with God, you just want to spend time with, with family and friends, I'm sure that the sisters can work something out for you. But really and truly, do come, give them a call. And it's St. Martin Retreat Center, and up at Monks and Irvans. And yeah, trust me, you would not regret coming to this place at all. I'm like, I just need to stay here. But anyway, I'm just grateful that I am here. So this morning, we're recapping. We have been having a good time with this whole land issue.
Yes.
Last time we spoke about acquisition of land through sale, inheritance, and gifts.
Yes.
So we're going to just chat about that just very briefly, and I want us to talk, if you can tell us about land tax, because oh my goodness, people, I believe that there are some issues there. Especially when you have to do it.
Yes.
When you have to pay, is it a set time? Things like that.
Yes.
So we can talk about that, and if we have time, then we can talk about wills, because we know for sure that, that's a whole, I'm hoping we have time for that. But we're not in a hurry, because we know we're here every month.
Yes. So the last time we were speaking about how land can be transferred, and we spoke about three main ways. Land can be gifted to you.
Right.
One person donates the land to the other, for different good reasons, but not money. Money's worth or love, affection, so forth. We also spoke about sales, and we spent quite a lot of time speaking about the sale when one person purchases land from another. What was the other one? From inheritance.
Yes.
So your parent dies, your mom passes away, and she makes a will and she conveys, she has 3 lots of land, she has 3 children, she gives for child number 1, lot A, child number 2, lot B, and so forth.
That's the ideal.
That is ideal. But oftentimes, a parent may have one piece of land with the family home, and this is all they had.
Yes.
This is all they were able to accomplish during their lifetime, or perhaps it was an inheritance from their parents, and they may have had 5 or 6 children.
Oh boy.
And now this has to be given away. And many times parents try to ensure that all of their children are provided for and that they stay together. Right. So they may give the 5 children this lot of land to hold it together as joint tenants or tenants in common. Equal shares, that's the term. You can either be a joint tenant or a tenant in common. These are the kinds of co-ownership when people are holding parcels of land together.
Okay.
And basically what will happen in either one of them, you're holding this land together, but it's difficult sometimes for people to unite and remain on the land. So it calls for a lot of maturity. I would even venture in to say,
okay, you owning it together. I understand the term, and we know what that means. But in effect, how will it really? Is it really working? Does it really work?
Well, that's why I was about to indicate it takes harmony. It also takes, I think, a great level of maturity and spirituality, because you have to respect people, you have to respect their boundaries, you have to respect that you may have different things going on and different plans. So one person may want to renovate the family home and one may want to leave it just as that, and they would have to come together to agree what to do. They're adults. Some may live abroad. One may be in Grenada, and so they may agree, for instance, to let the child who's in Grenada live in the family home. And then when they come on vacation, they would obviously be able to have a room. But that's a give and take, because the one in Grenada must now may have their family and must now allow their sibling with their family to come and room in that house, and you can see the potential for conflict.
Oh yes, definitely.
So it takes a lot of maturity and spirituality, because you must now accept that this other person has a right, has an interest, and sort of be amicable about it. And not a lot of people can be like that, you know. It is oftentimes it gets to the court and it gets to me, lawyers and some of my colleagues, to try to sort it out. But I always vow and try to accomplish what is in the best interest of the clients and get the best possible outcome. Usually, so it may not, I always try my best to see if I could meet the lawyer, talk, mediate, do some more interventions, try to see if I could quell heatedness from my client's end, because I'm only responsible for what I could say to my client. I can't determine what decisions they will make, but I know if I'm in the physical situation, I would want to live in a peaceful way. So I also try, when I'm giving legal advice, rendering legal advice, to help people remain cordial and sane and try to do the right thing, because sometimes you may have people winning the cases and they're not happy at the outcome. They're just angry.
So I was about to ask, and that's what I was saying. Usually, is it that they would, in cases where there's a lot of conflict, when they join, you call it joint tenants?
Joint tenants.
Right.
Yeah, well, co-tenants. It's called co-tenants, because joint tenancy is a specific kind of co-tenancy. And I will explain the two and the differences in few seconds.
No problem. So, how would it get, if it gets to the place where it gets to court, or well, maybe I should say get to you or to a lawyer, is it mainly because of conflict or whatever, or just the fact that they've been given the land and they have to share, that is, you understand, that they have to now come up with some kind of condition or whatnot to be able to share? Is that it?
So oftentimes, I always say the problem is never starts legal. It ends up legal. Legal is more the symptom of an ongoing issue. Right. Because if there is harmony, then they wouldn't have an issue. But sometimes a person may feel that in the island, let's say all the family members have remained abroad for 30 years. And this one person is living there with their family. Right. They may feel that they've acquired a legal right against their sibling.
So have they?
Well, in short, if there is a will, no, because they've got
exactly. That's
and
what I'm
even
saying.
if they haven't gotten a will, you can't really, in a sense, get adverse possession against your sibling, because you would have started with equal rights. The person may not have been there, but the courts have had a dim view, and they've interpreted it as, when one sibling has tried to oust the other one, the courts have never really allowed that to happen.
Okay.
And that is under the Possessory Title Act. This is the precedent that has been established. They normally would have the persons go back and deal with this as an administration matter and not as a litigation. So the one person generally would not win the case against the sibling. That's what would happen. And then the lawyers would know how to finish the administration to share the property equally. But sometimes you have subdivision, and this one may say, well, I don't want down here. Or this one may want the flat part. And so sometimes these are the issues. But if there is unity, you would accept. Sometimes they say it's supposed to be equal, and then you have the interpretation. So for me, I always say equitable, not equal. If you have a lot of land that's quarter of an acre and you share it up with a few people, some persons may get a larger portion of land and some a smaller portion, because you have to subdivide. And the physicality of the land may not allow you to split it up in equal pieces. Right. You might have a big stone, for instance, in the middle of the land. So you can't pass a road through it. So you have to go around. Right. So the one person may end up getting the big stone. So their portion might be bigger because they're getting a big stone, and you might have to get a smaller piece because you're getting nice flat or undulated land, and it's fertile land. Somebody might have a waterway passing through or a drain passing through theirs, so they might end up getting a bigger piece in terms of when the surveyor is preparing the proposed plan. Right. And it now takes a lot of maturity and good spirit, I would say, to accept or to negotiate or to talk to your sibling about what you're getting, as opposed to fighting out in court and going to make an applications, your partition application to subdivide. Sometimes the parent wants them to live on the property together. Oh boy. But sometimes you can't, and sometimes you have to accept as siblings you cannot, and it's better, even though this is your parents' intent or intention, it is better for you to subdivide it and each of you hold your share severally, instead of holding it together, the entire piece of land, as co-tenants. Okay. If I may, just for the viewers, did you have a question, or should I just explain the co-tenancy?
Explain it, and then I will ask. It's because you mentioned the big stone. You use it as an example, yes, but I was just wondering that if you see, instead of the person getting, let's say, quote unquote, the bigger portion because you had to go around the stone, would somebody say, let's blast the stone? You understand? So there is they would do all of these. Of it may be prohibitive, and you may be talking about humble people of little means, and they're not in that position to blast the stone. So then it's just go around. Sometimes we're talking about a road, but this road may just be a plan of where the road will go, and it may not be a nice road where you put down your BRC and you pave it. It may just be, for now, you're walking on a track, and in the next 20 years you're going to be able to pave it. Because it's there is a practical element and there's a theory, and sometimes they don't all come together. And like I said, the reason I spoke about that is because on paper the plan, it always looks perfect. Right. But most of the plans you're seeing, they're not topographical, they're not showing, and Grenada is lovely. Lush vegetation and high hills. On a hill. You put on a hill as though you are burning a tree. But on the plan, it always just looks like a diamond or a square. It's just beautiful.
Yes, it's always beautiful when you look at it, and when you go to the land, and then people have their own idea of what is the boundary.
Oh yeah, we have to talk boundaries. Hopefully we'll get to do that.
So and who want where this mango tree is, because they remember they used to pick up mango here, and this other sister want this mango tree. And you'd be surprised what people make confusion over. And that's when I said it takes a lot of maturity, because sometimes all it is a memory of something, and the tree doesn't matter. And if you're good with your sister, you could come and pick up mango under the tree. Anyhow, but if you sue them, you're unlikely to be able to set foot on the land. And I've seen it, funny enough, with siblings. I've seen it with uncle, nieces, nephews. You've seen it with different dynamics. And it's very ugly when you meet land matters involving family.
Oh, boy.
I don't know about my colleagues, but for me, it's very difficult to have to deal with it because there's the emotional side and trying to ensure there's healing, even if there is a court matter going on. So you have the partitioning, and some families do it with no drama, no problems, and some pull cutlass and it ends up in the criminal courts, unfortunately, because it starts off with this and then it becomes boundary dispute, or then it becomes a hibiscus tree or something, a peach tree that coming over, a coconut that fall in my side, a pear tree.
We have to talk about that, but
and then somebody pulls a cutlass and they damage someone and problems. Sometimes it's neighbors.
You remember when we spoke one of our programs before, we mentioned when you defined what land is.
Yes.
We spoke about even the airspace and all of that.
Yes.
So this thing with the peace tree or the pawpaw tree and the branch coming over on whose side, who is the fruit on that part of the tree really for? Is it that the person, because it always causes a confusion. You hear people talking about this thing in Grenada. So is there a legal thing to that in truth? Is it who really owns it? Is it the owner of the tree?
A little complicated. I mean, let me see how I can deal with it. The courts have, in fact, had judgments where if a view, for instance, was blocked, it was seen as a legal right to the owner of that view. Right? So if I have my lot of land and you have a separate lot of land in neighboring my land, and you've done something which has obstructed my view, the courts have upheld that I have a legal right to that view because I have suffered a loss. This brings intrinsic value.
It's a loss of my view.
Yes. And if the court has been so liberal to interpret a view on the neighboring land, which is in the neighbor's land airspace, so to speak.
Yeah, exactly.
It must also mean, well, that's why I said it's a bit complicated, because you have the peach tree, which is on this side going over the other side, but in the other side where it's going, it's in your space, so
literally
in your
my land.
I do know under laws of, for instance, like nuisance, you can abate. Abatement is a remedy where you, for want of a better word, hopefully simplistic, better way of trying to explain that remedy is you fixing it yourself. So instead of going to the court, you try to fix the problem yourself. Of course, you can't break the law in doing it.
Hold on. So you can't cut up. So if Dwayne's peace tree, Dwayne and I are neighbors. I just want to make sure that this is very clear because it happens so often. So Dwayne and I are neighbors. Dwayne's peace tree is now over on my side. We actually have a fence. We were good, but until his peace tree came over. Now, if I just trim I trim it off, he still has most of his peace tree. Right. But I trim off the part that is over by me. Is it legal for me to trim his tree that is in my land?
Pretty much that is what abatement is. So you can first speak to the person and say, you have a tree, can you correct it? Can you cut it from your end? It's coming over mine, it's causing destruction. Pieces falling in my yard or whatsoever piece thing. I have to clean it up. It's costing me, my gardener, extra day work to clean up all these leaves. This is a value. And you give them an opportunity. If you're, well, you can try to be nice and do just that.
Right.
Which I would suggest. And they would say no. Or they would not answer you and they would leave it, let it continue. Or they would just cut it. And solve the problem. These are the options, really. And, so you must know, if they did not fix the problem themselves, then you can trim without trespassing on the neighbor's land.
That's what I'm saying, because you in your land. So in your land, you can just take on the part that is
so that is abatement. If you trim the tree from your end without trespassing on the land, you've improved the problem. You've rectified it. You've not encroached. So that is abatement.
Well, if I go over in his land, because I need footing to cut the tree properly, I'm now in trouble.
You're in trouble, and he can sue you for trespass to land. He can probably also sue you. He can sue you for waste damage to land, that is damage to land, being waste. Oh, and waste is a long and complicated one too, because waste could be improvements, so to speak, to land, or cutting timbers, wood, so on. You could, if you're passing a drain and you're digging your drain, but you realize you must pass through your neighbor land to get water out, and you dig through the neighbor land, you might be thinking you're helping the neighbor too by this improvement, but you one stepped on the land, which is a trespass to land without the consent of the owner, and two, you've dug a drain, which is removing the soil, and that is waste. Ameliorating waste. Ameliorating waste. Cutting the tree, you may think you're improving it, but damage to land because the tree is part of the land and you've cut it from the neighbor's land. So damage to land. But if you do it from your side, it's seen as abatement, which is why I said it's a little complicated. It is complicated.
Okay, so what if I pick, we're still on the peas tree, because as I said, I know a lot of things come. So I didn't make any confusion with him
about,
but I like peas, and his peas is now my peas. Or is it really my peas? Because it's now over, it's his tree, but it's in my land. So can I pick the peas legally?
Well, personally, I wouldn't pick the peas because my father would probably turn in his grave. And I had a situation where my neighbors, sometimes beautiful things, sorrel and stuff would be coming over. And I would say, oh gosh, I could do with some sorrel. Like, don't you touch it. And then the neighbor will come and he would invite him. No, he would invite him. You come across and pick the sorrel coming across. So I'm watching him and, you know, like, but I'm greeting the neighbor and being cheerful because, you know, it's just a running joke. But yes, so technically, yes, you can pick it. But if it is going to cause conflict, I would say no.
Just simply inform.
Because I try to be non-conflicting and non-harming in my personal dealings. But it is not that you cannot pick it because it's on your section.
Right.
But you know, oftentimes, something so simple.
And can become an issue.
People could get a feel of things based on the situation. You must know the relationship you have with your neighbor, and even the neighbor will, you know, bend. If the neighbor is going to feel strongly about it and cutlass go and pull, then I think you should just exactly.
Okay, so the police could get if Dwayne's tree is still there. So I am not so sure about Dwayne and whether or not he is going to maybe pull cutlass. I don't want to pick the peas. I'm not so sure about abatement. Can I call the police and just tell the police, well, can you all cut the tree? Because I mean,
the police would not
cut the tree. Right.
You can call the police. The police.
I mean, we would call police. And this is not to suggest to give the police more work. Please.
No, and that's why I want to.
We just looking at the other scenario.
That's why I want to deal with it very clearly. The police is not a jurisdictional issue. It's a jurisdictional point. Police deals with the criminal aspect of matters, but the police also does community outreach and so. So oftentimes the police would be the contact person where a lot of civil matters go through, domestic matters go through, family issues go through. And when you come to them, they will tell you, well, this is not a police matter, but I would suggest you go to a lawyer, I would suggest you do. So they will still point you in that direction. However, if it is that there is a conflict which may potentially be a breach of the peace or lead to a breach of the peace, then the police will come to ensure that the peace is not breached or that nobody commits an assault or any offenses, including the language offenses like obscene language. You know, sometimes people get very angry and they say lots of things. Now, when they do that, the police has jurisdiction.
Right.
And then you can have charges flowing, and this is something that you really want to avoid. So oftentimes when people are handling issues with land and so on, they may call the police just for police presence.
Right.
So that everybody can do what they're supposed to. So for instance, if you need to abate because you've spoken to the neighbor and you find there may be an issue, you can contact the police to say, there's an issue, I would like to remove this that's coming over. Right. I've spoken to my neighbor, but I'm not too sure if there will be a conflict while I'm doing it. Do you have somebody that can come to just supervise? I'm doing it, the police.
Of course. Definitely. That's not a
so that if I am doing it, there will be peace. Right. That even if the neighbor tries to make an issue, there won't be any cutlass pulling us because there's police presence. And oftentimes we do that when there is surveys We don't call the police because the police has jurisdiction on a survey, but we call them because the presence, the authority, the show of authority would often cause people to behave themselves and not commit criminal offenses. And that's what you kind of want to prevent.
Okay, that's very clear. Wonderful.
Yes.
Okay, so we're going back to yes, the definitions. So we're right on track.
Right. So you can own land, number of persons, 2 or more persons can own land as joint tenants or as tenants in common. This is the ways of co-ownership, right? The joint tenant will have to obtain the land at the same time. There's a couple of unity, or get the land at the same time. The same instrument, the same deed, right? But I think the most important distinction between the two is that when one person dies, the share goes to the remaining co-tenants. It does not pass on to anybody who survives them, like their children.
So the core one is like husband and wife.
No. I don't want us to look at it in terms of it at all.
Oh,
Let me go back. The avoidance of doubt. Parties such as husbands and wife often choose tenants to hold as joint tenants, right?
So they don't have to.
No. And I'll tell you why.
So I thought it was automatic. So
no, it's not automatic. And now, especially with divorces, so sorry to say, it's not even advisable. Let's start with what is the definition of it, and then we can go to examples of it.
Okay.
So a court, there are different types of court ownership. And the significant difference between the joint tenant and the tenants in common. There are some others, but the one that is major is the fact that when one person co-owner die, their share goes to the remainder. I wanted to explain that in this way. You and I are siblings, or let's say there's a husband and wife, right? These are just the examples, right? Now, if you're holding such joint tenants, if I die before you, predeceased you, then my share goes to you. So if the land was 1 acre, this entire acre goes to you.
Not mine. Okay.
Now, when you're holding this land, this 1 acre of land, both of us are holding 1 acre. You're holding 1 acre, I'm holding 1 acre. That's how it works with joint tenancy.
So there's no share. Half.
You don't, no.
Oh, but that's interesting.
So that's why I need to explain first before we go to that, because that will confuse viewers.
Yes.
So you're owning the whole of the land. Both persons are owning the whole undivided portion of the entire lot of land. Okay?
Wow. Okay.
And when one dies, it goes to the other. So that if you have children, it's not affected. The last surviving co-tenant in a joint tenancy gets the entire piece of land.
Okay.
And that's why it's probably good for siblings or it's good for husband and wife.
Right.
But nowadays, right, and sometimes siblings want their property to go on to their children. So that's why you go to the second type of co-ownership, which is the tenants in common.
Right.
The tenants in common is basically persons are holding the land in same shares, in equal shares or in shares. Right? They could be unequal shares, but it's usually in equal shares. So you have 4 siblings, each person is holding a quarter share. But the land is also undivided. There's no division. It's not been partitioned.
Right.
But you just know you have 25% of the land.
Of that.
But where your 25% falling is anywhere. You're holding 25%, whereas in the other one, you're holding all of it.
Right.
Now, the tenants in common may hold it with different times and with different instruments, because you may be siblings, and then when one dies, their share goes to their children, and now their children have inherited their mother's quarter share. So these 3 children are now holding their quarter share with their aunts and uncle.
Ooh.
Right? So that's how it gets complicated, and that's why sometimes people say, let's partition it so that I get quarter of an acre, you get
and then I can figure out
if I'm only going to give one child, because then it gets split up, and then because it's undivided, you don't know which share which part of the land is yours. Because you know you have quarter share, but you could use this cherry tree and this pear tree, and you could pick from everything.
Okay.
Because it's undivided land.
Yes.
That's the whole purpose of co-tenancy, that you could use all over. But
So how would you build? If someone has to then build, then that cannot work now.
Well, they agree. Usually they agree, and all of them are there, and then it keeps getting smaller with the tenants in common, because the shares keeps having to split up with the more people, but each person is having a certain percentage share, because that quarter share is what is being inherited, nothing more.
Yes, yes.
You don't get peace from your auntie unless she gives you her quarter share.
Right.
So if she has 5 children and your mom has 3 of you, so there's 5 and 3 is 8 plus the 2 aunt and uncle, and they have, and it's only if they decide they're going to give this next generation. Right. So that's what it can be. So about the example with the husband and wife.
Yes.
Husbands and wife, a lot of times these days, they do the tenants in common, because it means each person is getting a share, 50% in advance.
Oh.
Right? And, you know, long ago, people just knew, I suppose they expected that if there was this one who survives, who gets all of it, if it was a tenant in common, will probably do the right thing and give it to their children in their marriage. But sometimes what happens is that partner may remarry after you've died, and they may have another family. And because they've now gotten all of it, you may have had children with them in your marriage while you were alive. But they have a second family, and you never know what their partner is like. Some partners want to get rid of the other family. It never happened. Some people are generous, and they say, well, this is the children, the lady's 2 children. This is your children too. This is my husband's 2 children. This is my wife's 2 children. So why not? Why can't I share the land with my 2 from my other spouse? And they leave out this too. So because you've gotten the entire lot from that joint tenancy, you're free to do with it what you want.
Okay, so when you purchasing land as a couple, you say no, because the reason I ask if it was automatic is because, well, you kind of thought that long ago,
and the dynamics in the society, it was cultural. Long ago, a lot of homes, the male figure was the breadwinner. So that if they were purchasing land, the male figure who was the breadwinner would probably put the land on both names, but the wife was probably a non-financial contributor, probably take care of the home and things like that, you know, because that was the dynamics in our context 50 years ago. That was the main dynamics. And so when one party died, I guess, I don't know if they figured the husband would outlive the wife, I'm not too sure. But it's just whichever partner, and I guess they had this one unit, family unit, nuclear family. Then, because divorce rates also was not very high at all. So the one partner will have the children of the marriage, and they will do whatever it is. And it would probably be coupled with a will. Right. But the fact about it is, the children of this marriage will get
more than
parents
would have gotten it.
Yes, from the surviving parent will have it all, and then when they die, all of it would go to the children in the perfect world. But we're not. And sometimes when there is a divorce or separation or death, you want to ensure that the children get a share, because remember, when there is a tenant in common, let me just explain. The share of the partner who has died is now divided in administration. So half share would go to the spouse and half share would go to the children.
Okay.
Right? Under the Intestate Estate Act, which I mentioned in a previous program.
Okay, wow.
Does that explain
it explains a whole lot, because to me, especially for viewers who may have been thinking like me, I believe a lot of people may have been thinking, oh, well, it's automatic, I'm married, especially with the marriage situation. I'm married, so, you know, I'm safe, quote unquote safe. But based on what you explained there, definitely. Okay, so let's take a quick break. And because that's a lot of information, we have to do that with it. And we'll be right back. We're in the right place for a good break.
And get repose.
All right, cool. So let's take a break and we'll be right back.
Thank you.
You are my strength, strength like no other. You are my strength, strength like no other.
And we are back. Thank you very much for staying with us. For those of you who may have just joined us, you are joining us from lovely Monks and Ovens, but I would not do the advertisement again. So Naeisha is with me, our legal representative from the CCG, and we are continuing to talk about land. Well, Naeisha, I don't know when we'll finish talk about land. We have a little while. We definitely have a lot, because it's a lot for us to just assimilate with that. And whew, I'm still breathing from all that you said before the break. But it's a lot of information, but it's really necessary information. So just to go back a little bit to what you were mentioning, and as I was saying, I know for a lot of people it might be that that thinking of it automatic. So that whole explanation on joint ownership and tenants in common and joint tenants. That is a whole window that you have opened. As it relates to having, so now that you have it, when I say have it, you own it. I just want to go back just a little bit to the tenants in common, because of course they just have it in the shares, from what I gather. Right. Yes. Now, you said more persons that are born, well, more or less, and more than likely will inherit this one little share. Once it's not partitioned, everybody technically own, but they don't know which quarter or which portion that is owned. Yes. So in order for anything to be done, is that where you will come in? Is it that you must now come to a lawyer or someone how exactly is this now going to be dealt with? Because now everyone is, so we're taking it for granted. I want to make sure I understand my own scenario. Everyone is alive. Right. So let's just take it with me and you. You have no children. I have 10. Right. But we are common, what do you call it? Tenants in common. Tenants in common. So we both have shares. Right. So both of us have shares. Half. Yes. But my half now technically have to be divided into 11 people. Persons. Of course, it would look like if you have a lot. Right. More. But it's not really that you have more. Really, we just have the same amount. Right. How now do I deal with this? Because I want to give some of my children the land or whatever. How do we deal with that now? So, in reality, what I've seen a lot of times happening is that people are living on the plot of land, the lot, as if the land is family land, and each person, if they're living on it, if it's not agricultural land, right? People are putting houses on the land, and it's often small houses, because what they would probably do is, after they discuss it perhaps with their parent, they may ask the aunt if they could put on a house temporarily on a spot. They may ask for a spot, and sometimes the aunt may oblige. And before you know it, every person is going to this aunt. So now you have 11 houses. A spot. And now when the aunt is ready to get the land, perhaps you have an improvement in their financial situation and they want to improve their property and put a larger house, then it's difficult to get persons to move. Oh boy. So that is sometimes when conflict will begin.
So that's why I said sometimes the conflicts are not legal. They're all the things you see in the Bible. Remember, I come from a position where I'm a lay member of the conference, so I'm very spiritual. So I cannot stress enough that a lot of the problems that end up in court can be settled on a table. Come to the conference room, ask the monks and others, and talk. And when you're tired of talking in the room or in an air-conditioned place, come to the summer house at the top and enjoy the view of Grenada.
And really just deal with
Pray and sing, and then you might be in unity with your aunt. So oftentimes that's what happens. So when you try to enforce now the legal right against persons who you've given a license to, there are no licensees. You can terminate the license. The person is occupying the share that you've given them. Remember, I said they asked for permission.
Yes.
So I use the legal term and then I use the lay person and I was switching. So for the legal jargon, you've created a license when you've allowed that nephew or niece to come on your property and put a house.
Right.
That's a license, a bare license.
Oh boy.
Okay.
But they don't have a deed and so forth.
They don't have a deed. Well, they wouldn't have a deed because you did not give
Correct.
them a piece of land. You did not. You don't make a gift of a lot of land. So there's no indenture. Right. But what you've done is permission. So that's a license you've created, and that can be terminated at the owner's will by telling you, I would like you to vacate, and you can, if you're not going, you can go to a lawyer and give them a notice to quit to move your house because it's a license you've given them.
But I don't think, Naeisha, that people understand all these things.
So they have to go because you are the one with the legal right, with the deed. And the legal right, and they're the person who said permission to stay there, and that's why it's better to put the permission in a written form.
Of course.
So now it's time to leave. So you have these 11 persons, and now they're moving, and then they try to take on the aunt's land, and then bacchanal, as we did say. Start confusion and chaos. So ideally, in the ideal world, the surveyor would be contacted first to see how they could, probably with agreement of the two sisters, to partition the land so they get the equal shares 50-50.
So that's the first partitioning.
That's the first partitioning would be to separate. And that plan would be what they would take to the attorney so that they can create a deed.
Right.
And the deed would be a deed of partition, which would separate the lands now into the two separate 50% lot. There will be lots.
And me now with my 10 children,
we have to
stick with our side.
And as much as possible, they would try to do the partitioning as best as they could with how the property is already in use.
Maybe how, just hopefully
there might be a little give and take where one person might have to break a kitchen.
Right.
But as much as they could, they would try to let the people who are putting the expense of putting their houses stay where they are.
At least, right.
As best as the land would allow.
Okay.
But you know, sometimes people make confusion because my aunt make me break my house, and the sister get vexed with the sister because what should you make me do? And your child coming from England, and they have all this pounds money, and you're better off than me, and then what you make me do, and we know how the story goes very badly
from there.
Yeah, from there. So the better thing to do is really to put it in writing, and it is possible for parties to agree to a partition of the land, even though your parents gave away the property in their will as tenants in common. You've divided the property for the absolute use and benefit of the persons in equal share. You've created a tenancy in common, but you can agree to you can agree to partition. And sometimes people say, but me and my sister good, me and my brother good, me and my uncle good. They're always good until that moment where they fall out, and then you say, and now it's very complicated to fix, and it's a 5-year lawsuit. Everybody wants it fixed now as in yesterday, and they come to the attorney and they go to the next one, and they go to the next one, because this one taking long and this one taking long, and then they say this court is slow and the court is slow, but the judges are limited, the resources is very limited. It's a very small state. We don't have a lot of judges, and we have a lot of problems, and unfortunately, we have a lot of land cases.
Let me ask this question. It might bring us into what we have to do next, as well as it may not, but you will guide me there. So, in the case of the tenant in common and the joint tenant, how are taxes paid?
That's difficult. In the sense that it's easy for the people at Inland Revenue. They calculate it based on the land.
Yes.
And the land is undivided. So if it is a quarter of an acre of land, 10,890 square feet, the land will be categorized, whether it is commercial, residential, agricultural. Agricultural, there will be no taxes. It will be tax exempted. If it's just a farm.
Right. Oh, it's just about, so if agriculture, okay, you know what?
So if they're not living on the land, they just, the land is diagnosed, the land is designated, sorry, not diagnosed, designated as agricultural,
right,
agricultural use, then zero.
Okay.
Right? Not complicated. But where is commercial or residential, there will be taxes and the rate would vary. The commercial being the most expensive.
Right.
Now, the parties who are the holders of the land must agree to divide the taxes and pay them.
Oh boy.
But in reality, sometimes one sibling may pay it.
And that is where this trouble starts again.
Right? If it's a husband and wife, well,
yeah.
It's sort of simple. One person pays the taxes.
Yeah.
You know, but where it's siblings or so forth, or other forms of co-tenants, because you don't have to be siblings. You could be an aunt and a nephew.
Right.
Remember,
Yes.
it goes down in different directions. And so you may find one person be having the pressure of paying the taxes, other people not contributing. But remember, paying the tax does not create any ownership, proprietary rights at all.
Just about to ask.
So you are doing it, and you can get compensation. Well, not compensation. You can get reimbursed. That's the word I want to use. You can get reimbursed for what you've paid. But you don't acquire a share. It's only government that could take your land for non-payment of your tax.
But that is an issue right then, Naeisha, because you hear, I have heard that as a big issue before. Well, I pay all the tax on the land for years now, I pay. And you hear people say that for years now, I'm the one paying all the tax and whatnot. And look, she come now and she want land. As though, as though that gave you the ownership rights.
No, it does not.
Viewers, and it does not.
Paying your taxes, I think I may have alluded, I'm not too sure. I say it all the time, so I'm not even sure where and when I may have said it. Taxes, Inland Revenue Department is only concerned with getting its monies for the government coffers. Right? So once the land is registered and you have, it says they have your tax ID, they would send you that notice. And they usually would send the notice to whoever is occupying the property, and the name would be the last name that was on the drawings.
Right.
The cadastral plan.
Yeah.
So it might be 4 generations, a great-grandparent name that might be on the property, and it will be still coming on this person in care of this other person, care of Naeisha John. You know, but the name might be 4 generations before. And you would now go pay the taxes, and that is what they're interested in, because they found you on the property and you said, I own it, so you put you in care of paying the tax. Nothing, you know, people use it as evidence of occupation or possession.
Right.
But that is all it is. You've been on it, you're physically there on it, or you're paying taxes, you're doing an act. But does that act singularly means ownership? The answer, short answer is no.
Wow.
All right, the short answer is no. Taxes are to be paid, and that is what government is interested in. No proprietary rights for you.
So even if you come with your million receipts, and you know sometimes people have the receipts from quite a long time.
You should keep them. You can.
I'm not saying no, but you know it's there so long that it's become. It's no longer white. Let's just put it that way.
Yes.
Very discolored, and of course you could barely see the ink.
Yes.
That it was printed with anyway.
You should photocopy them, because
as soon as you
print.
Get it,
the print
it really does go away.
Okay.
So that settles that with the taxing as it relates to that type. When it comes to general taxing of land, is it a set price, or is it always based on the size of the land? What is it based on? I know you mentioned, of course, agriculture already, but the other three.
Yes.
But still, how if someone had to, because you hear people saying things like, oh, the government cheating me. You hear people say all kinds of things. Of course, we know that is crazy, because there must be some kind of formula.
Yes.
You know, So how is it if someone, is it like, for example, based on whether or not it is a concrete structure, is it wooden, you understand what I mean? Generally, just the basic things. I'm not asking here for the how much you have to pay. That is not what we're trying to get from Naeisha, but just generally, what kind of gauge do people have to use?
Well, I think I might be the wrong guest. I have a couple of friends
Oh,
in
no
the
problem.
Inland
I can-
Revenue Department. But from what I've understood is there is an index, there is a mathematical formula, of course, that the Inland Revenue Department uses to calculate. And just from my experience, observation, speaking with persons at the office, I do know that certain things are taken into account, particularly the valuation of the property, and certain things would determine that.
Right.
I think just like any other qualified valuator will do, the Inland Revenue representatives would go to the property and examine it. They have personnel. I know that because I've had experiences talking to persons from there who's gone to properties and so forth. They've gone in the field, they would look at the property and they would do an assessment. And that is how they would also categorize properties as being agricultural, commercial, residential. Because a property may start off in one
I was
category.
just about to ask that.
It
If
may be
I purchase agricultural land,
and over a period of time, the whole area may become a residential area.
Exactly.
And it happens all the time. You have large tracts of land which were estates where they used to farm on, and then they now cut them off and they're now a residential area.
Exactly.
So the purpose of the property, the land, would have changed substantially. Sometimes you may miss it because you may have put a house there, and because the representatives, they're limited. It's a small department. They may not have gotten to you, and you may have gotten away with living on a property that's without paying taxes because it's
because it was agricultural
then categorized as agricultural. You have a mansion on it, and they missed that one. But once they've done that, they will assess it, figure out which category it falls, and work out their formula. So like I said, it might be location and valuation, concrete house, so many bedrooms, so many bathrooms, what is the area, close to school zone, close to hospital, close to road, close to other facilities, whether it's flood prone, flat, hilly. They look at different factors, and they will determine what is this valuation you are placed to it, and then they would work the formula on it.
I think it would be nice for us to have one of your friends from
for
real, if we can at least just get that. And of course, it's not to say, well, that is not the person coming and say, this is how much you won't pay this year. Of course not. But it's just frivolous. That it will make us understand. Because I think that simple things like that, people do not understand it. People do not have the information regarding it.
And then we know that the index changes too, because sometimes the structure, tax structure, can change. For instance, government may in the budget increase taxes on everything. Sometimes taxes go not only for land, but sometimes you may have changes in policies. So sometimes your income tax may have all the taxes in the country have changed. Sometimes there may be introduction of new taxes. So that's a whole other system, and that happens in line with government. So that is a decision of cabinet, and the policies may change and decisions may come out of it, and then they may be restructured and legislation will be passed by Parliament to enforce this new tax. So so they may have a 50% increase.
Or whatever.
I'm just so sometimes it's not inland revenue that just improve, but it can't be because it's legislative. So the point about it is, it's not frivolous. There is a method that they use to calculate, but there is also other outside policies that may affect taxes, and they may be just a decision that more income needs to be collected, revenue needs to be earned, and they may have a restructuring of taxes and increased taxes. So that is that. I wanted to just add, I don't know if I'm preempting, but I wanted to add that once there is a transfer of title from one landowner to the other, Inland Revenue will know And the reason I'm saying this is because in order to get your deed recorded, you must get your tax clearance certificate. And you
Right.
can only get that when you present your signed indenture, original indenture that I spoke about the first
Yes, yes.
session with the red lines.
Yes.
When you present that to the Inland Revenue, and they will check the records and ensure the taxes are cleared as is property
Okay.
tax.
Right.
And then you would get that tax clearance that you can record. Now, if it is a sale, and you
That is where I
will
was
have to
going.
do your
Exactly.
property
So if I-
transfer tax.
So if I,
and that's
because I
another
have
formula.
to, so if I have to purchase from you,
Yes.
and who it is that has to do the paying? Is
The
it
vendor, the person
who is
selling
selling
the land
has to
pays
ensure
the
that all taxes and so forth would have been updated,
Yes.
and then the new owner will pay from
then on. But there'll be two taxes on a sale. There will be the property. There will be the property tax, which is present for any transfer.
Right.
Once you transfer in a title, whether it's gift, inheritance, the tax must be cleared.
Right.
But there's a property transfer tax that operates mainly when you have a sale. When one person is selling land, that vendor would have to pay a property transfer tax.
Okay.
Now, if it is a gift, there is a certain amount that is exempted. My memory, and it may be subject to correction, is that there's a cap on the first $150,000.
Right.
And if the property is more, then you pay
Then
on
you
that.
pay on. Okay, interesting.
Right, but
Very
I
interesting.
may have it
I know,
wrong.
yeah, but generally, but
Yes.
there is some kind of
Yes.
cap.
Some
even
of
if
the
figure is not
matters
the-
too that I do have my office staff assist me with some of them too, so they're
Right.
more au fait with the day-to-day
Yeah, the actual amount, but I
administrative
get
and the
you.
calculations and so forth.
And I think that is very important to know because, especially like when we use the example, one of our programs before, when we were talking about someone who they purchase it and maybe they just give you, well, maybe not even a receipt because you're all tied,
Yes,
whatever,
yes.
and now, so because if it is that we didn't go to a lawyer and I just say, oh, well, I give you, is a little piece of land, I give you, we agree for $10,000, $14,000, I give you. Maybe you did give me the receipt and we did whatever, but the point is that I just assume I had the land, and well, I think that is where a lot of the problems again will come up.
Right.
Things like taxation and
Yes,
so.
because the previous owner, there will be one registered owner in Inland Revenue. There will be one registered owner in the which is probably going to be the same name.
Right.
Likely to be the same name in the Registry of Deeds and the Deeds and Land Registry. Deeds
Right,
And Land
yes.
Registry. So you have now been occupying the land for 15 years, 20 years. You grew up your children on this 30 years, but all you had is this receipt that you've lost, like damage in Ivan or something, and now difficult to get your title on your name, and now your children have to try to figure it out.
Okay. I don't know, do we have the time for us to begin to look at wills? At least just, we can start it.
We do a teaser, say,
Yes, just a little
like
teaser just for the last
since
few
we're talking
moments
about
that we have.
advertisement and lots of
Exactly.
television things today.
Yes, let's just talk a little bit about wills. At least we'll begin it, and then we can continue next month, God's will, at our new program. So just basically, because we just have just a few moments, because we're still talking land, of course, what I would like to ask just briefly about will is, what really is a will, and when should you write your will? That just those two questions alone, and then we'll take it from there next time.
Yeah, excellent.
Yeah.
I like the second one. I love the second one. I would start with the first. A will, I would say it's a document. I wouldn't describe too much the form in terms of how you put it.
Yeah, not
you
yet.
put it.
We'll do that
But
later.
it is a document which is made by a person in anticipation. Well, I don't want to say in anticipation of a death, but it's part of anticipation, it's part of preparation for the eventual demise. So that whatever assets, properties, whether they are real properties or personal properties. Real properties will be real estate,
Right.
land,
House.
so forth, and personal property, car, clothing, fittings, fixtures, things around, I don't know, jewelry,
Right.
shares, accounts held at the bank,
Okay.
you know, things, shares at the credit union, stocks, you know, Grenada shares,
Right.
things like that. How would you like to make provision for those persons who mean something to you,
Right.
out of these assets that you've acquired in your lifetime?
Okay.
The will can include properties that you have or properties that you intend to have in a
Right,
future
because you
time,
know-
because you may anticipate you will do a sale, or you may anticipate you're going to sell a house in Bathway, and the proceeds of the sale you would like
Will
to
go
give it to
towards-
this particular person,
Okay.
or the church, or some organization. But it is a document that is made by one person, anticipating the eventual death. Some point we know we're born and
Yeah.
we will die at some point, and we, just as we prepare our spirituality, we prepare for
Of course.
our assets.
Of course.
And with the hope that there will be no conflict, and that someone will be appointed in this document to give effect to it, to
Right.
distribute all the different properties.
Okay.
And of course, that document has to be witnessed by 2 witnesses.
Okay. So
Regarding your last will and testament, is there something specific why, or that's just a name? That's my last will and testament.
okay, so that has to do with how you actually begin to prepare it. So we're leaving that for the next program.
Okay.
Yeah. So we'll go. Well, you'll edit that out. So when should you
Right.
do? So just go on to that.
You should do a will once you've acquired the
Something
age
to
of
give away?
21.
Okay.
And you have assets, you probably have
you
a
don't have
house and a mortgage and so on. Well, at age of consent, so 18.
Right.
By
Okay.
18, you can do a will.
Right. You
But
don't have to
you
wait
may
till
not-
you're old and dying.
You don't have to wait till you're old, and you don't have to wait till you're ill, because
Right.
people die at 20.
Exactly. That's the point I'm making. But people
But
usually
you
think.
generally tend to have, you may not, of course you wouldn't be able to enter a mortgage until you're 21. So
Right.
I put that age.
Yes.
You know, we have different ages of consent.
Yes. for
Contract would be
different-
8,
Yes.
contract like those things, mortgages and those things will be 21. So that's why I
Yes.
put the safe age at 21, where you will prepare your will. And most people won't, but when you get a little older,
Right.
you will. You acquire a car, you have bought some shares, you open an account in a credit union, and there's compulsory share buying there.
Yes,
So you have
yes.
few shares, you have 5,000 shares, I don't know, 3,000 shares, some shares. You want to make sure you give that to a particular person, because if
Right.
you don't have a will, when you die, what will happen is the Intestate Estate Act will operate to give the shares. I think I would have explained how it goes. If you don't, you have your parents only, they will get it.
Yes,
if you
we have
no
mentioned
children
that.
and so forth. So you make the will to ensure that your intention is carried out. So you may not
Right.
have wanted this person. You may, for instance, you may have met a girlfriend, the love of your life, and you want that person to
Yes,
have
yes.
something. And if you didn't do that, you're not married.
Exactly.
They're not going to
They're not
fall
gonna
under
be.
the Intestate Estate Act, or you may be in a common law relationship for 40 years.
Wow. Yes.
And this is not provided in our law yet, so this person will not inherit, and your brothers and sisters
I
who
know,
didn't
who
like the
didn't-
lady, who never talked to you since you got with her, will end up getting
will-
everything.
Correct, because you did not make that provision. Okay.
Yeah.
So, deliberately a teaser. But we are going to take the time that we need next month, God's will, to be able to look at this topic in detail. Because I do believe, oh boy, it's a lot in there. In
lot,
terms of
it's a
even
lot.
how to do it and so forth. So, viewers, we just, giving you just a little taste. So, those of you who want to learn about writing your will and so forth, of course I can quickly say to you, just go by Naeisha, but the thing is that you still need to understand what's going on there.
Yes.
So we are going to talk about that next month, God's will. Naeisha, thank you so much again for coming.
Always my pleasure, and thank you for and having me enjoy this space.
Oh,
I live
yes.
close by, but I can't get enough of Monks and Ovens. It's
Well,
absolutely beautiful.
Well, now all I've done is gotten a taste, and I have to
You
become
have to
even
come back.
more friends with the sisters here, so I can just come and do what you get to do, what you got to do years ago, which is to just come and just enjoy this. So thank you again for coming. Viewers and listeners, thank you very much for staying with us for our hour. See you and have next week, Friday, God's will, and have yourself a really great rest of your day. Goodbye.
You are my strength.